Before we get started with today's In the News segment, I want to be sure to reference you to an article about the difference between service animals and companion animals. During our discussion, we were referencing an article that talked about them as kind of interchangeable words, but really, when it comes down to it, there is a difference. And if you go to rentprep.com/landlordu, we'll have a link to an article that explains the differences between the two. And now let's move into the show.
Nothing will crush a real estate investor's spirit like landlord stress. The difference between being successful and miserable in managing properties is education. Welcome to Landlord University, where landlords learn. Landlord University is recorded from inside the RentPrep office, where Stephen White and Jeff Pearson share the lessons learned from working with some of the most successful landlords.
Welcome to Landlord University in the News. I'm Jeff Pearson, and this is my co-host,
Stephen White.
Hello, Stephen. How are you doing today?
Hey, pretty good, Jeff. Excited for another episode. Excited to have Jennifer on here, and we've got two articles that are related. So that doesn't happen too often. So I'm excited to jump into them. They both relate to pets and landlords dealing with pets one way or another. So Jennifer, take it away.
Well, yes, it was interesting to have a couple of pet-related stories this week. This news story comes out of Oregon. It has to do with companion animals, which is a gray area for a lot of states. The tenant in this case is bringing a lawsuit against the property management company that was trying to charge her a pet deposit fee and a monthly pet fee for her companion animal. And the lawsuit is looking at the different rules that exist about with disabilities and service or companion animals. According to the fair housing laws, management can't charge pet fees. They don't have the right to ask for paperwork about the service animal and whether or not it's been trained, which is a common out of property management companies. They can't restrict a tenant from having a companion animal, and they can't even restrict the breed, except for one exception, that if a landlord's insurance company allow a certain breed, like Rottweilers, for example, because they consider the animal dangerous. So this lawsuit is being brought by the tenant against the property management company, and has to do with companion animals. And a lot of landlords aren't familiar with companion animals and the laws surrounding them. So I thought it would be an interesting topic to jump off from.
Now, and I've read through the article, and I don't know if I'm missing it or where it states in it. What did it ever really highlight what the reason for the companion animal was? Was it like I've heard of seizure dogs, dogs that can detect seizures, things like that. Would that be considered a service animal, or is that a companion animal?
That's a great idea. My understanding, and I may be wrong on this, but for a service animal, to do kind of more with like a medical need. I know there's like diabetes dogs that can help diabetics sense when their blood sugar is low, but a companion animal, I believe, is probably more for like a mental, sort of like for depression or for those sorts of things.
One of the things on this article that it does mention is that they use companion animal interchangeably with service animal. So I'm not sure that there really is a difference. I've heard both terms used before as well, but I don't know if there is a legal difference. So I would say for the purposes of this article, we'll focus on companion animal or service animal being the same thing. The question is, does it make sense for service animals to have additional fees and can they be allowed?
Yeah, that's a gray area, and I could definitely see a gray area between identifying the difference between the two. And it's interesting. I never knew that that they weren't required to explain what the disability was, or also to show paperwork for the animal. As a landlord or a property manager, I definitely would be interested to see that. I mean, what type of animal is it? What's it for? I can understand kind of both sides of it. You want to protect the rights of the tenant. But at the end of the day, it's an animal in the property. So, I again, as looking at this from a perspective of a landlord, I'd want to know. What's the breed? What's the, has the animal been trained, or are you training the animal? I think those are all legitimate questions. So it's definitely, yeah, it's definitely kind of a tough call, a tough situation here.
Yeah. Now, it mentions in the article that the only exception to the housing laws is that management can refuse a tenant's animal when the property's insurance carrier says it will cancel the policy or raise their rates exorbitantly because they deem a certain breed of animal dangerous. And that's what the managers of this place argued.
Mm,
We don't have the details of what the breed is. I think you had mentioned that before, Steve. But
mm.
essentially, like you said, it doesn't matter what kind of animal, it doesn't matter what kind of training. If somebody claims they have a service animal, the fair housing rules say you have to allow it.
Yeah, and it's, again, if, especially I've talked to so many landlords who have had, horrible animal situations and have that policy of no, it's an absolute hard no. There's no pets allowed, no animals allowed because of a bad situation. So it could be a tough pill to swallow for a landlord that now has to just accept it and hope for the best, really, that, well, let's hope that the animal is trained well, or let's hope that the animal doesn't destroy the place like the last tenant that I had, or, something like that. So it's tough. It's a tough situation.
It does mention later in the article that property owners are allowed to ask tenants for paperwork from a doctor, social worker, or other qualified person certifying their need for the animal.
Well, that's a step in the right direction, because that's definitely, well, but again, okay, so you get that paperwork. Does that really, for the landlord, does that really give the landlord any, anything to go off of other than knowing that now? I mean, it's not like the landlord can say no. So,
Exactly.
other than the breed, which we mentioned, that would be the only reason you'd be able to. But so I don't know. I mean,
And
that,
then you
that
start to get into a situation of at what point can you ask for that information? Um, if somebody applies, first of all, do they have to tell you that they have a service animal before you accept their application? And then secondly, if they tell you they have a service animal, then you're starting to get into a discrimination situation where if you don't rent to them, they could accuse you of
yeah,
discrimination because they could say the only reason you did turn them down was because of their service animal,
right.
which goes back to what we've talked about many times before. Make sure you establish the criteria and follow a documented process for how you decide which people you're going to rent to.
Yeah, for sure. You want to make sure that, if you are going to deny them, you have everything documented and you show pretty good reason why you went with somebody else, and, that you have, your screening criteria. And obviously, the animal can't be considered at that point for the screening criteria. But like I said, there hopefully, for the landlord's sake, there's something else in there that may have jumped out and said, okay, we've got a better qualified person, if that's the case. If not, then it sounds to me like you really don't have a whole lot of choice as a landlord in this situation. You got to accept that person.
Exactly. So again, it would make sense to check with your insurance company to be sure that whatever type of service animal they would like to have with them is not going to have a significant change on your insurance. And short of that, you have an obligation to rent to them if they're the most qualified tenant.
I would wonder about what, assuming that the tenant is in with the service animal. So at that point, what pet policies are you able to enforce? If the pet is causing damage, if the pet, is threatening children or whatever. At what point is there a difference where enforcing your pet rules or general pet rules would cross a line into a discriminatory action?
Mm,
That's something that I thought of as I read it.
That's a really good question. I think that's one of the types of things I was thinking as we were talking about this. We do need to get an attorney onto the show at some point in the near future. And this would be a really good topic to discuss. And I think those questions are really good, Jennifer, because, yeah, I mean, if you've got a service animal, or, let's use that in quotes, service animal, and this is somebody who doesn't have a trained animal. Seeing eye dogs are something that we're very familiar with, but there are service animals for so many other things. And then you start to get into the question of, is this truly something that you can control? If there is an animal that is a behavior problem and you have a no pets policy to begin with, but then you've got an animal who is harassing the neighbors or the neighborhood kids or whatever it happens to be. What rights do you have at that point? And I think it would be a really good discussion for us to get into with somebody who really truly knows the laws. And this is a federal law, so I would think that this is something that we could talk about and have it apply to people across the country.
Yeah, I'm thinking again from a landlord perspective, what a nightmare that would be. You got a service pet, and the service pet just so happens to turn out to be destructive or choose through the doors or something, and what a nightmare. Now you've got an issue where how do you really deal with that? I mean, you want to be careful, obviously, that you're not discriminating them, but the animal obviously is a problem or causing damage. It seems like a nightmare. No matter how you spin that, it's going to be a problem.
Very much so. Well, staying on the topic of pets, we have another story that talks about cats. So, Jennifer, tell us about that.
Sure thing. This is a really sad story about a landlord who's been accused of stealing his tenant's cat. The story is that the tenant came home and found that her cat was missing and had no idea what had happened. So she posted some reward notice and things like that around. And apparently, then the landlord came forward to her and said that he had entered her unit, taken the cat, and taken it to a shelter where it had been euthanized.
Mm.
The tenant says that there was no prior notice, no phone calls, no emails, no text messages, nothing from the landlord that said, you can't have a cat. I'm going to come take it if you don't have it gone by, whatever day. Basically, the landlord walked in, took the cat, and took it to the shelter where it was killed. The story does point out that there is a no pets clause in the lease that she signed, so she was in violation of the lease according to the story. But the policeman that they'd interviewed, it doesn't matter. That was in the lease. That there are proper ways to do this. You wouldn't walk in and take somebody's TV or take a tenant's property in any other way without these proper steps of notification and that sort of thing. So it's an interesting story where the tenant was in violation, but that the landlord went way, way outside. And again, not even just taking the TV, but basically, had this pet killed. So it was a
Yeah.
really sad story.
Yeah, and I unfortunately I know this type of landlord. I see a story like this, and I see, a landlord that let his emotions get the best of him. And a lot of landlords have this sort of mentality of you're in the wrong, and so now I get to do whatever I want. Kind of like that case that we saw last week, discussing the landlord who hired the thugs to get the woman out who wouldn't pay. You just can't do that, and obviously if he had he didn't give her any kind of written notice or anything like that to enter the property, it's wrong. He's stealing. He's going in there and taking this woman's cats. And as much as he may have felt that he had the right to do that or get rid of the problem, or that while she's violating her lease, you just can't. I can't think of a situation where this is going to end well for him.
No, and I think it's interesting that the sheriff said that if there's a covenant in the lease that says they can go in and remove the animal, then yes, they can do that. If the sheriff really stopped to think about it, at what point can you write into the lease that
Yeah.
as long as you sign this lease, I can do it? We'll go back to the thugs. If you put a covenant in the lease that says if you don't pay your rent, it's okay for me to have my thugs come
Hmm.
break into your house and beat you up. And as long as you sign that, then is that okay? I mean, this goes way beyond
Hmm.
reasonable. You can't put a covenant in that says that
Yeah.
if you have animals that you're not supposed to have, we're going to come in and take them and euthanize them. That's ridiculous. And
Yeah.
again, just thinking that since I put it into the lease, I'm covered. No, you have to do things that are legal and proper, both from a legal standpoint as well as going back to the ethical and moral aspects of it. It's just not right.
Yeah, I'm just imagining, our form bundle containing an addendum that says, go ahead and sign this. That says that we can just enter your property at any point and just take your stuff, and you're okay with that, or come in and beat you up. It's crazy. I don't think that any tenant would stand for it, obviously. And yeah, I agree with you. The sheriff, I think, probably just going with the safe answer of, well, if there's a covenant in the lease, sure, you can that may have flown, but I can't imagine that there would have been, and I can't imagine that anybody's going to sign off and agree to that. And it's just crazy.
Right. Well, the other piece to that is the landlord went into the property and retrieved the cat, according to the article. So are you saying that in a lease, you could put an addendum that says, oh, by the way, I can have access to your home anytime I want without any type of notice?
Definitely not. There's over and over again in my research, the landlords, of course, have to abide by municipal and state laws. And over and over, it's been shown in court that just because a landlord puts something in a lease, if it's different or the state laws or the municipal laws, then it has no standing. So in this state, as in many other states, there are very strict laws about landlord access to units. And in order to enter a unit, unless it's a case of an emergency, there has to be, most states, at least a 24-hour notice that the landlord will be entering the rental unit. So, but landlords, probably try and stuff all kinds of crazy things in their lease agreements. But if it is in violation of a state or municipal law, then it has no validity.
Yeah, I think I agree 100% with you there. I mean, even if they had it in that, even if for whatever reason he did have an addendum that said that, and whatever, you're right. You still have to give that 24-hour notice that you're entering the premise, and
why.
And why,
you
exactly.
Have to say why.
Yeah. Yeah. You have to say that I'm going to be coming in 24 hours to grab your cats up or something. Yeah, clearly he's in the wrong, and I don't think that there's any way to be right in this situation. I don't think he could have had an addendum or anything in the lease that would have protected him in this case. He just, very black and white to me. He's in the wrong. And you're right. No matter what any addendum says, you still have to abide by those, the right to enter laws, and you can't just go in there any time that you want.
I agree. This is somebody just stepping way outside the boundaries of reasonable, both legally and ethically.
But I've seen, like I said, I know this landlord. I don't even have to know his name. I've talked to enough of them. I know this type of landlord. It reminds me of the same kind of landlord that, whenever I'm doing a speaking engagement or anything, and and if ever the topic of cash for keys comes up, and you have really two very basic trains of thought when you talk about things like that. And on one hand, you have the reasonable side that says, well, it's going to save me money in the long run. I'm going to end up having, allowing to get this person out of the place. And then you have the other side that, total prideful situation where they're, I can't do that. The tenant's going to win and I'm going to lose. And, it's my place. I can do what I want. I have this right. I have that right. And so again, I think when the landlords start acting too emotionally, not treating it as a business, treating it as this is my stuff, not yours. I can do whatever I want. They're just getting themselves into all kinds of trouble.
Yes. Well, great. Thank you, Jennifer. Those were two very good articles, and it'll be interesting to see if we get some feedback from some of our listeners on their thoughts on these as well.
You're welcome. If you come across any interesting news articles that you'd like us to discuss, feel free to send them in. We'd be happy to take them apart and see what lessons we can learn.
Absolutely. Well, Stephen and Jennifer, thank you very much. I look forward to talking to you next week.
Thanks, Jeff.
Thank you.
Thanks for listening to Landlord University. And remember to visit rentprep.com/landlordu to see show notes and access free resources like forms and guides. And be sure to check out Jeff Pearson hosting his own hit podcast at thementorimpact.com.